The last attachment on page 10 says 2018-0703 audio with a number.
787, it's also on page 8, the top of page 8.
Yes.
Yeah, and then
Now-
there's also photos of the J88 that was inside the docket at the time.
Yes, the J88 appears on page 9, the second last photograph on page 9.
That is correct, Commissioners.
Is it correct then that, especially when you make reference to the J88, that these documents would have been the content of a docket?
That is correct.
It's a proper description.
That's correct, Commissioner. It would have been in the docket itself.
Thank you.
And then if I could just ask you, Colonel, why was it so concerning to you that the suspect in this case, General Khan, had been given the contents of the docket? I know you say there's issues about he may influence the investigation, but at which stage, I mean, we do know that if somebody is then charged as an accused person, they are entitled at some point to the docket. Why was it a concern that it was at that stage?
Commissioners, when we got hold of the docket, because we went to the police's archive and we physically fetched the actual docket, it became clear from the docket and the entries in the docket that General Khan would have been interviewed on, and now I have to rely on the date that the interview was held, and I can't remember that specifically on the top of my head. But he was supposed to be interviewed by the investigating officer on that specific day, and he received this document just prior to be interviewed for a warning statement on that specific day. So he would have known the contents of the complainant's statement prior to him submitting his warning statement. And to me, that's a huge red flag and a very huge concern, because you're not entitled to any statements at that point in time. You're entitled to what the charge is. And I think in this case, it was assault common, happened on such and such a date. That is what you're entitled to. And they do give you that information when they take your warning statement. But to come to the investigating officer with a prepared statement, warning statement, seems to me that you had to have prior knowledge of your version of events based on the evidence that was given to you and on which you can base your affidavit. So that was my biggest concern. We can't sit and put our thumb on the scales of justice one way or the other. It has to be done correctly.
In sum, you are saying having the complainant's statement, there was, at the lowest, there was the possibility of him tailoring his version in accordance with the content of the statement.
Yes, Commissioner. In fact, I will go a little bit further than that, because there's no other reason as to why you want the complainant's statement beforehand. You want to see what she's saying or he is saying. Yeah. And you have to then, and you will tailor your version in so that it does with what the complainant says. So it's difficult for me to understand any other reason for you doing it, because that's the only inference that I take away from this, and that is why it was so concerning. And I mean, this kind of modus operandi is being, I've seen this before, where suspects get access to documents prior to them having warning statements, or prior to them when they are supposed to be, when they're only entitled to have documents. So this does happen, and in this specific case, it did happen.
How does that differ from a situation where before a witness testifies in court, that is a criminal court, they actually do get the statement? So in a sense, one could say or make the point that the situation is similar. So what's the difference?
No, it's not similar, Commissioners. From my point of view, and I mean, as an investigating officer, it is very important to me to, when I do a warning statement, that I inform the suspect of the complaint, not what the witness was saying, because I need the suspect's version of events, if he is going to give it to me or not. That's a different ballgame. If he's not giving it to me, then obviously I can't take it further. But if he is willing to give it to me, I can't tell him beforehand what the suspect said, because it's unethical and it's not allowed. So,
Thank you.
Can I just find out, in the normal course of events, when does a suspect become entitled to the contents of the docket? So
normal
if things are done procedurally, when does the suspect become entitled?
procedurally is when he's either represented or not represented, and the court and the case is before court, and there is a disclosure to the defense, either through his lawyer or to himself, the suspect himself. That is when you get entitled to the documents,
So it's after you are charged,
after you
not
charge.
during the investigation?
That is correct, Commissioner.
Thank you.
But Colonel, at this point, Ms. Johnson would have been in the NPA at this point.
That is correct,
That-
Commissioner.
Is there in terms of process, is there a legitimate basis on which she would have had access to the docket at this point of things?
No, Commissioner, but I just want to make, to clarify, we're talking about 2018 now.
Yes.
Yeah. No, there was no reason for, it was a station matter. In other words, it was confined to that specific police station. And I can't remember which jurisdiction in terms of court they fall under. What did I say? It was a Silverton case.
Silverton, yes.
Sorry? Silverton case, yeah. So they would have fall under that jurisdiction of that court, for that area. So in the normal course of business, she doesn't have any reason as to why she wants to get hold of the docket. And in fact, if she wanted to get hold of the docket, she probably would have been able to. She could have just called for it because of her position within the NPA. And I think she was head of organized crime at the time, if I'm not mistaken. So she would have been able to call for the docket in her capacity as an advocate within the NPA. And whether there was a reason for her to call for it, I don't know, because it would not normally fall within their mandate, what they investigate and what they prosecute. But under normal circumstances, there is no reason for her to request a docket.
Thank you.
And also other situations where there would be early access by prosecutors are those instances where the investigation is prosecution-directed. So there are those instances where,
Yes, but
yes. I'm not countering what you said. You are saying, but
no. What I'm saying is, at the time, you must remember this is at the station level. So you're talking about prosecutorial advice in terms of a docket. What I can't say now is whether the docket went to a prosecutor before the time or not. And if it did, yes, that prosecutor can have access to guidance.
I'm just talking generally.
Yeah, no, I understand that.
Yes,
So,
yes.
but she could have contacted prosecutor as well.
Yes.
So she didn't have to contact someone else.